Buenas and half a day, everyone. Good morning. This virtual hearing, public hearing by the Committee on Public Accountability, Human Resources, the Guam Buildup, Hagåtña Revitalization, Regional Affairs, Public Library, Telecommunications, and Technology is hereby called to order. The time now is 9:02 a.m. and today is Friday, December 17th, 2021. For the record and in accordance with the open government law, notices for this hearing were sent out on December 10th, 2021, and again on December 15th, 2021. In addition, this hearing was noticed on the Guam Legislature's website. I'd like to thank my colleagues for joining me this morning for this hearing. Welcome Speaker Therese Terlahi, Minority Leader Cruz, Senator Telo Taitague, and I believe we have Majority Leader Senator Telena Nelson signing on right now. Welcome and Siduas Masi. Before we proceed with the discussion, I'd first like to provide some general rules of conduct for everyone in attendance. The conduct of this hearing shall be as follows. All must abide by the rules of conduct and quality assurance standards. Please keep video on at all times and ensure that you are in a room with little interruptions and adequate lighting to ensure your face is visible. When speaking, please make sure that you are unmuted and you are speaking into your microphone. The chair will invite individuals who have signed up to testify. The order of questioning will begin with the panel of senators, and it will complete with each respective agenda item. Each member will be allowed to pose questions to the panel, and we will provide an additional round if needed. Questions and testimony today shall be confined to the substance and nature of this agenda. Personal inference as to the character or motive of any senator or individual testifying is not permitted. Any violations of this general rule of conduct will result in removal from the meeting room. On the agenda today, we have Bill number 219-36LS, introduced by myself, Senator Amanda Shelton, Vice Speaker Tina Rose Muña Barnes, Senators Telena Cruz Nelson, Mary Camacho Torres, Telo T. Taitague, Frank Blas Jr., Joanne Brown, and V. Anthony Atta, an act to amend subsections A and B to add a new subsection G of all of section 41210, Article 2, Chapter 41, Title 17, Guam Code Annotated, relative to the certification of disability as an impediment to employment for individuals with disabilities. And Bill number 221-36LS, introduced by Senator Telo T. Taitague and Senators Sabina Flores Perez, Joanne Brown, V. Anthony Atta, and Frank Blas Jr., an act to add a new section 6104 and section 6105, all of Article 1 of Chapter 6, Title 4, Guam Code Annotated, relative to the public disclosure of quarterly staffing patterns and personnel information reports, increasing transparency and improving data articulation for fiscal accountability and planning. We'll begin with the first item on the agenda, Bill number 219-36LS. I introduced Bill number 219 to increase access to employment for individuals with disabilities. It's my hope that Gov Guam will be the model of inclusivity and diversity for our entire workforce. Bill 219 will allow individuals with disabilities to apply and be considered for jobs within Gov Guam with greater ease. I want to thank my co-sponsors, Vice Speaker Tina Muña Barnes, and Senators Telena Cruz Nelson, Mary Camacho Torres, Telo T. Taitague, Frank F. Blas Jr., Joanne M. Brown, and V. Anthony Atta for their support of this measure. I also want to thank our partners at DISID for bringing this issue to our attention in an earlier hearing with the department. Bill 219 is a result of our conversations with DISID to ensure a mechanism is in place for compliance with Guam law requiring 2% of our government workforce be individuals with disabilities. Bill 219 amends this law by giving the responsibility of certifying a disability of an individual to a qualified and licensed medical professional under Guam law. The certification of disability will address the applicant and knowledge of the job site, job description, workplace disability safety, and knowledge, abilities, and skills required to perform the job. The medical professional will also be responsible for making recommendations to modifications to the job or job site and other accommodations that can be helpful to ensure successful placement and support of an individual with disabilities in the workplace. The current law requires an applicant to be registered with the Division of Vocational Rehab, DVR, at DISABILITIES and be certified by a counselor at DVR. The bill will allow individuals to certify with their trusted doctor without being a consumer of DISABILITIES and allow the department to focus its limited resources on other vital services. To encourage compliance with the 2% law, Bill 219 will require GovGuam agencies to also submit an annual report to the Department of Administration that will detail the number of individuals with severe disabilities employed by the agency, the total number of employees employed by the agency, the number of individuals with severe disabilities hired by the agency within the year, the types of jobs these individuals perform, and the length of time these individuals were employed in each agency. With 219, we can work towards our goal to give more individuals the opportunity to use and develop their skills and provide the resources they need to assert their independence. We must break down unnecessary barriers for qualified individuals to access opportunity and employment. Our government exists to serve the people, and by building a workforce that is representative and inclusive of all, we can best serve everyone in our community. So thank you very much for the opportunity to hear this bill and to our partners who are here to testify. And I look forward to hearing from our community members today and from our senators here for discussion to strengthen this measure. So Dios Masi, everyone. Now I'd like to invite individuals who are here to testify. I see Acting Director Michelle Perez from DISABILITIES. Please state your name for the record.
Good morning, Senators, Senator Shelton, Speaker Terlahi, Senator Nelson, Senator Taitague, Senator Duenas, as well as everyone else here today. I do not have written testimony at this time, but I will provide that to you, Senator. However, I would like to just put for the record that, I'm sorry, my name is Michelle Perez, the Acting Director for DISABILITIES. We are in support of the bill. The intent of the bill is really great, as we've mentioned before in several different public forums during our budget hearing as well, because it was brought up then, and also during our oversight hearing. Of course, there are some things that we would like to suggest, to make the bill more well-rounded and more, the intent being more well-versed for everyone and, beneficial to both the agencies, but most especially individuals with disabilities. So yes, we are in support of the bill. I'm here for any questions that you may have.
Thank you very much, Acting Director Perez. Can you share with us some of those recommendations at this time?
Sure. So I don't know if you want me to go via each line that I kind of briefly went through. So like if you go to page 2 on your draft bill, on line 14 to 15, line 14 and 15, it states to demand equality and be recognized as a contributing participant. Our suggestion from the team was to just let it read to equally recognize a contributing participant instead of demand. I mean, it's kind of minor, but my team felt that it would be more appropriate to use that word. And then if you go down to page 2 again on line 18 into 19, some points to consider would be replacing determining eligibility and vocational rehabilitation needs to certifying disability. And the reason being, the medical practitioner's main role would be to certify the disability, right? We all know that certification can only be done by a medical practitioner.
Pardon me, Madam Chair. Am I looking at the wrong version? Because what she's describing, I can't find on my version of the bill.
Sorry, I'm trying to find it also.
Point of information, Madam Chair, it's a draft bill that she's reading off of. If you just follow along, you'll be able to find the keywords that she's talking about. It's in the same page.
Yes, it's
I
still on-
apologize. This is what we received. So this is what I was going off of.
Okay, I'm using the bill as introduced on the website, and we'll put the link in the chat here for everyone to follow along. But yeah, we are still on page 2. It's a different line number, but on page 2.
Okay. I apologize. I don't have that version, Senator. I'm
So
just going based on the draft bill that I had.
So for page 2, it's on line 19 where it says to demand equality and be recognized. The recommendation is equally recognized. You will change that verbiage. And then on page 2, line 7, instead of the responsibility of assessing and determining, you cross out determining and you write the word certifying, correct?
Yes, ma'am.
Thank you, Ms. Perez.
I apologize. Like I said, so I think it's going to be
Can you repeat the second one, Senator Nelson?
Yes, Madam Speaker, the second one is on page 2, line 7, where it says vested with the responsibility of assessing and determining eligibility. Instead of the word determining, we are replacing with certifying. That is the recommendation.
Okay.
Thank you. Please
and-
continue.
yes, sure. So our reasoning behind that was, like I mentioned earlier, the certifying individual would have to be a medical practitioner, whether it be a medical physician or a psychiatrist, right? So DVR cannot certify, no one else can certify disability. And then of course, in that sense, that the individual based on his or her disability meets the criteria to be counted as part of 2%, because there is a criteria, right? There is a, based on the Rehab Act, as far as what is defined as a severe disability. So they're the only ones that can provide that certification. And, I just want to make sure that everyone is aware that it is important to understand that Voc Rehab Services has specific criteria for eligibility, right? So having a disability does not automatically qualify you as an individual for VR services. And hence the reason why this bill, we're supporting it, because it's not just funneling everyone through DVR, because not everyone is eligible for DVR services if they have a disability, right? Let me see. So I'm not quite sure what page this would be for you folks. On my draft bill, it's on page 3, and it reads, it starts on line 12, which says Guam license. It's crossed out where it says counselor from the Division of Voc via DVR. Then that's crossed out, and it says.
Yes, so that's
Guam
our line
license.
15, everyone. Mhm.
I'm sorry, go ahead. Line
No,
15.
it's our line 15, yes.
Okay, so it just says Guam licensed medical practitioner under 10 GCA, Chapter 12, qualified to determine whether an individual has a physical or mental impairment. So that whole section to line 25. Sorry, my. So this says this section is based on the DVR counselor's assessment and eligibility criteria for VR services. So it's not the medical practitioner's certification of disability. So I'm not sure if we suggest that it should be removed and just as the responsibility of the medical practitioner, because this is what the DVR counselors do for eligibility criteria for VR services.
So the recommendation is to strike that whole section.
Yes,
Up
ma'am.
until medical practitioner. Okay, thank you. Okay, please proceed.
And then on page 4, on page 4, where it talks about the certification must be supported by, which starts on page 3, and then it starts giving you the different types of what the Guam licensed medical practitioner provider in the what they document. So from lines 3 to 13 on my draft, which starts off with letter A, ability of the proposed applicant to do the job based on the recommendation and need for the job coach.
Mm-hmm.
The team feels that the job coaching is something that is determined by a VR counselor, right? So the medical practitioner does not know what the actual job is, does the job entails, right? So mainly the job can be, the eligibility criteria for the job and the job skills is more determined based on DOA and how the job description is laid out, as well as whether or not when they're in that job site, for example, for job shadowing. So they're gaining the experience. The medical practitioner can't say, yes, he needs a job coach if the medical practitioner really has no knowledge of what the specific job is, other than what is written on the job description. So it's to indicate here that they need to be part of the process to recommend a job coach would be, is not recommended by the team. It should be more or less the team that's actually working with the individual at the job site, if I'm making sense.
So the recommendation is to strike letter A.
Yes. So, and it goes back to the fact that this is geared more to individuals with, that are under the program with DVR. So the DVR counselor is the one that determines if a job coach is needed, and so to assist the consumer successfully performing his or her duties on the job. So the medical practitioner can include in their recommendations and suggestions sections B, C, and E, which works better for what their role is in certifying the disability.
So the recommendation is also to strike letter D.
No, so you could keep B, C, D, and E, but to just strike out A.
Okay, thank you.
Okay. And then on line 26, where you go into Government of Guam departments and or agencies may meet such criteria through direct employment or by contract with non-profit organizations employing individuals with disabilities. Direct employment is through DOA, right? So, or does the individual have to be a DVR consumer was the question that was brought up. I don't know if anyone, if
yes, so the intent of the bill is that they do not have to be a DVR
Correct.
consumer. Mm-hmm.
Yeah.
I think her version of the bill is different at this part, Madam Chair, from what she's reading.
Yeah, I think so too, because we updated it before in the newest introduced version. So if you can use the one that I put in the chat box, that link, we can use that to go through the markups.
Okay, I'll try. I apologize. Like I said, I did not get this updated version, so. Sorry, I'm trying to pull it up, but it's not letting me. I would think that with whatever my notation is in the draft bill comparable to the version that I have that you just sent, there may be, I would like to reread it to determine if there was any significant changes. So I don't want to, start giving comments and then you're like.
No problem, Director. I think that some of the recommendations that you are giving now are recommendations that you gave us at an earlier time that were adopted in the introduced version. So okay. Yes, please refer to the introduced version and provide us that testimony and recommendations in writing.
Okay, I appreciate it. I apologize again to the panel, to everyone here.
No, thank you very much for for being here today and for providing that testimony to begin with, and for your support of the bill. So would you like to say anything else before we move on?
No, I'm just, like I said, I'm glad that we're moving forward with trying to provide more opportunities for individuals with disabilities, so that not specific just to individuals that are under DVR, but, you know, island-wide, so that we can all be able to they can all avail to the opportunities of being a Government of Guam employee. Thank you.
Thank you very much, Director. Is there anyone else here to testify on Bill 219? Okay. No, thank you very much. We'll open the panel now. We'll begin with Speaker Terlahi. Do you have any questions?
Thank you. Yeah, I wanted to find out from Director Michelle if we want the medical practitioner to certify that the person has a severe disability, or you want them to certify something else, like all these other things, that whether they're able to work and things like that.
Thank you.
This language keeps repeating. It says whether an individual, and it's different from the definition of whether they have a severe disability. So they're only supposed to be qualified if they have a severe disability, according to your definition here in the statute. But then it says they're going to certify, or that the individual has a physical or mental impairment, which for this individual constitutes or results in a substantial impediment to employment, and which this individual can benefit in terms of employment outcome. And actually those two seem to contradict each other. So I'm wondering if we're trying to get them to say, first of all, whether you have a severe disability, which makes you eligible for this program. Second, whether it's a substantial impediment to employment, meaning you can't be employed, or whether, and is that supposed to be an or, the individual can benefit in terms of an employment outcome from vocational rehabilitation services. And now they're talking about vocational rehabilitation services, not employment anymore. So I don't know, that's why it's confusing for me, but what do you want the medical practitioner to certify exactly?
So in the current statute, thank you, Speaker. So the current statute states that DVR is the certifying agency, that a DVR counselor has to certify that the individual has a severe disability, right? So
okay, just whether or not they have a severe disability.
Correct.
Right?
Yes,
okay.
Yes.
Yeah.
And, you know, based on what the current statute states, severe disability, the definition is based on the Vocational Rehabilitation Act. Right. So that's what we are following, and I believe that's what needs to be very clear, right? So yes, it would be just to make sure that the definition of severe disability, which is the criteria to meet the 2%, is clear on the bill.
Okay, so the medical practitioner certifies whether under our law they are a person with severe disability as defined in the Rehabilitation Act, the Federal Rehabilitation Act, and then after that certification, then the DOA and DVR, they come in, and DVR can come in with assistance or other types of things, and DOA will come in and whether they're qualified for the job.
So DVR, okay, and I think what we need to make sure everyone understands is that once the medical certification is done by a medical practitioner certifying a disability, now DVR, if they're found eligible for services with DVR, then they can go that route, right, for employment and other DVR services. Now, for example, if they do not meet the criteria for DVR eligibility, or they just don't want to go through DVR, right? Some individuals just they feel they don't need to go through DVR. Some of them want to be more independent and try and get the job on their own. So if they go straight to DOA, filling out a job application for DOA or other Government of Guam agency, the certification of disability indicating that they meet the 2% disability, then that's what will be used for the agency to account them for being part of the 2%.
Okay.
So that, you know, the intent of the bill is basically to, at least our understanding is to not limit individuals with disabilities on how they can apply, or even how they can apply for Guam jobs.
All right, and also to to continue to allow DOA to determine job, whether they need the
Qualifications.
qualifications for the job. Okay.
Correct.
All right. Thank you.
Yeah.
Thank you, Madam Chair. No other questions.
Thank you very much, Speaker. Majority Leader Nelson.
I have no questions at this time, Madam Chair.
Thank you very much. I'd also like to recognize Senator Perez. Thank you for joining us. Senator Perez, do you have any questions?
Yes, thank you. I'm so sorry I was late. Yeah, so maybe this is a question for Michelle, the acting director. So can you, maybe you covered this earlier, I apologize, but so the current statute basically allows the counselor from your division to certify whether someone has severe disabilities. Can you explain the improvement of this change, what this bill proposes to do?
So thank you, Senator. So basically the current statute, that's what it states, is that the DVR counselor is the certifying individual to determine the disability of, severe disability to meet the 2%. Now, that in itself, the DVR counselor can't do that, right? Because we don't certify disability. And I think it's just a matter of tweaking the verbiage to state that. What currently is happening now is when an individual is a DVR client, and then they, for example, go and they apply for a job at any of the line agencies, right? And on that, what they're stating is that what we can certify is that they're a client of DVR, but they can't certify that they meet the 2%. You see, based on the definition of the 2%, which is severe disability. So I believe what's been happening is there's just been a confusion of how to determine or how to count them as a 2%. The only way to count them now based on the statute is if they're a DVR client, they meet the 2%. That's how the understanding of how the agencies are looking at it. But technically we are not, DVR clients are not certifying. We cannot certify that. We can certify that they're a DVR client, but that's about it.
All right, thank you for that response. Yeah, no questions, further questions. Thank you.
Thank you very much, Senator Perez. Senator Dueñas.
No questions at this time. Just like to thank the acting director for being here and providing updates and opportunities to make the bill stronger. Thank you, Madam Chair.
Thank you very much, Senator Dueñas. Senator Taitague.
Thank you, Madam Chair. Is there a fiscal note? By the way, I didn't see a fiscal note.
I have not seen one uploaded yet. We have not received one at this time, Senator Taitague.
Okay, so I appreciate to have that fiscal note as we move forward on this bill. That provides us a lot of insight.
Sure, we'll request it.
For the record, is the term, good morning, Michelle. Thank you so much for being here, by the way. And for the record, is the term Guam licensed medical practitioner in Bill 219 recognized in the 10 GCA Chapter 12? And if not, should another term be considered to ensure consistency with the applicable laws? That's for you, Michelle.
I'm sorry, is it for me?
Yes, yes.
Oh, I'm sorry.
No worries. You need me to repeat it?
Yes, please, Senator.
No problem, no problem. Just for the record, the term Guam licensed medical practitioner in the bill, it recognized in 10, is it recognized in 10 GCA Chapter 12? And if not, should another term be considered to ensure consistency with the applicable laws?
Okay, first of all, Senator, I don't know if it's actually recognized in 10 GCA Chapter 12. However, I do know that if there is another term besides Guam medical licensing practitioner, then it would be considered to be changed. I do know that when we spoke with Senator Shelton, she did mention that she wanted to ensure that the right terminology was used to make sure and to determine that not only a psychiatrist, a licensed psychiatrist, but also a licensed medical practitioner, because those are the two individuals or two professions that can provide the certification. I hope I answered your question, right?
I think that we're still, trying to get additional, at least allow you more time to look over the bill, because the one that was introduced, any kind of confusion would be adjusted by giving you a little more time to review the bill. So that's just a question for you to also do in your research as well. Can you tell us, what data is available on the number of individuals who have been hired by government of Guam for the past 10 years pursuant to the 2% law?
DVR, DISIT does not have that data.
Okay.
We don't, and one of the reasons for that is the fact that we are not an agency that is privy to personnel information that for others that are being hired. So we do not have that information.
But isn't that some kind of, isn't that information important for data, especially when you're dealing with federal funds to provide information?
Yes, but like I said, that is not information that's part of our preview with regards to DVR, and our grantor does not ask for that information because it's not part of our DVR services that is required with the grantor, the federal side.
Okay.
This is a local statute.
Okay, can you tell me then, with the situation of the 2%, what happens if there's only one employee in an agency to meet the 2%? For an example, the Women's Bureau, Commission on Decolonization. What happens when there's only one employee to meet that 2%?
I don't know.
Sure.
We don't. We are not. We are not compliant. We are not the ones who do compliance for that particular.
Okay. I thought, okay, no worries. Well, Madam Chair, for the record, I'd like to read into the testimony from Mr. Joseph Cameron, who was the director of the Department of Vocational Rehabilitation, which later became division under the creation of DISIT. In total, Mr. Cameron directed vocational rehabilitation services on Guam for 8 years. He was also a former director of the mental health during the administration. Mr. Cameron has served on the Guam Gumamami Board of Directors for many years. And I'd like to read his testimony in for the record. Hafaday, Senadora Shelton, the following comments are preliminary and will require additional review. Washington, D.C. U.S. DOE Rehabilitation Services Administration is currently reviewing Bill 219 and finds several concerns. I'm aware that your office will be sending testimony expressing their concerns. The DISIT is the designated state agency which has the Division of Vocational Rehabilitation under its umbrella agency. The Division of Vocational Rehabilitation is a designated state unit, DSU, whom receives federal funding under 34 Code of Federal Regulations to provide Guam eligible consumers vocational rehabilitation services. The DSU agency must determine if additional state plan descriptions reflect the current administration of vocational rehabilitation and supported employment programs. If any descriptions, assurances, or the certification section does not meet or reflect the current administration of the agency, the VR DSU must submit an update description, assurances, and certification with its submission of the VR portion of the state plan. If the DSU VR makes any substantive changes as proposed in Bill 219, it is policy and procedure governing the provisions of vocational rehabilitation services, VR DSU, must amend the VR portion of the state plan prior to the implementation pursuant to 34 CFR 361.20 of the VR regulations. Has your office received actual information as aforementioned federal requirements by the DSA DISIT or that from DSU VR? Signed, Joseph Artero Cameron. Thank you, Madam Chair, for allowing me to read his testimony into the record. He was unable to make it this morning. He has a prior engagement. And that's all the questions I have for now, other than just looking forward, to maybe even having another public hearing on this, with considering all the other information that was provided today. And appreciate your time, Michelle. Merry Christmas to you.
Okay. Thank you very much, Senator Taitague, to address some of the questions you had earlier about the medical practitioners. So yes, the code calls them all practitioners. So that provides the definition for each profession. And so that's why we included it under 10 GCA chapter 12. But if you need more clarification, we can get that for you. Additionally, to Mr. Cameron's testimony, we are in receipt of that testimony, and it will be included in the committee report. It is being forwarded to the committee. So we thank him for that testimony, and want to thank also Acting Director Michelle Perez for your time and for the team's time and review of this bill, and we'll look forward to your written testimony as well. Just to make the point very clear, we're not amending any of the state plans or the statute of vocational rehab under the department, but this is a bill rather to address concerns in the DOA hiring process and allow for an easier hiring process for individuals with disabilities. We are not adding to the work or subtracting from the work of the Division of Vocational Rehab. We are addressing our local statute by breaking down barriers to access this statute that has been on our books to allow compliance for the 2% within the government of Guam. So I thank everyone for their testimony. And with that, we conclude the public hearing for Bill 219-36. Sudios Masi, everyone. Speaker.
I just wanted to, since you were in receipt of that testimony by Mr. Cameron, if you had forwarded it to DISID and if DISID had any input on it. Because
I just received it as well. So no, I did not give it to DISID yet, and it will be uploaded to this drive.
You just received that? I thought I saw that. Okay.
Yes. So we will,
because I wanted to ask this whether it would have an effect on their state plan or not, as he's describing.
Okay, you may ask a question.
I have not, sorry, Speaker, I have not received that testimony, a copy of it yet.
All right. Okay, thank you.
Okay, thank you very much, Speaker. Thank you very much, Assistant Acting Director Michelle Perez. Thank you for your time. Merry Christmas. That concludes our public hearing for Bill 219. We will now move on to the next agenda item. Okay. We are on Bill number 221-36 LS, introduced by Senator Telo T. Taitague and Senator Sabina Flores Perez, Joanne Brown, V. Anthony Atta, and Frank Blas Jr. I'll now ask Senator Taitague to give her opening remarks on the bill. You're muted, Senator Taitague.
Classic. Classic. Always forgetting. But anyway, self-named Madam Chair, and thank you for the opportunity to briefly speak on the measure. Madam Chair, I want to take this opportunity to express my appreciation for scheduling the public hearing before the holidays, especially on needed legislation that increases transparency and access to information of Government of Guam, employment and hiring practices. Bill 221 places the hiring practices of our government back in the hands of the public and policymakers. Madam Chair, Public Law 36-54, our FY22 Budget Appropriation Act, provides that staffing patterns are quarterly uploaded to an agency's website. Line agencies are batched and uploaded by the Department of Administration. Only the autonomous and semi-autonomous agencies, the judiciary and the mayors, are required to transmit a copy to the legislature. Madam Chair, to ensure that we enact policy that becomes permanent and not when this legislature includes it as part of the budget law, Bill 221 permanently codifies within the Guam Code Annotated, the transparency requirements and content of staffing pattern reports. Madam Chair, currently, quarterly staffing reports exclude much information that should be public information and made available in the first place. Unfortunately, staffing information published by the Department of Administration comes short in meeting the requirements of law. This is an issue that with the consistency of information posted online, which is not complete with the law's reporting requirements. As a result, unfortunately, the posted reports are not useful to any legislative standing committee or even the OPA. Madam Chair, a large number of FOIA and informational requests from this legislature, the public, and the media are regularly sent to our agencies that continuously swamp and interfere with their day-to-day operations. I don't believe this is intended to harass an agency, but simply acquire information that should have been public knowledge in the first place. Madam Chair, this legislature regularly calls upon the agencies at public and informational hearings for staffing pattern information, raising basic questions that should have been included in the quarterly staffing pattern reports. Unfortunately, many folks find it difficult and in many situations cannot make heads or tails on quarterly reports published online. The introduction of Bill 221 is long overdue. Madam Chair, with great access and clarity, Bill 221 strengthens a level of accountability for our government agencies to present an accurate snapshot of their hiring practices, attrition, and migration of employees within agencies that have been temporarily reassigned. The current quarterly reports are two-dimensional, and at most, a list that shows a pay stub connected to a name. Bill 221 provides three-dimensional perspective that allows for the critical review of an agency's existing workforce levels and needs. Madam Chair, Bill 221 will represent all terminations, promotions, demotions, temporary details, transfers, reclassifications, internal agency movement, and external migration that will be represented and captured each quarter. In addition, monthly personal information reports will also support it. Each report is due 10 days after each quarter for staffing report, and monthly for personal information reports, which most likely will be a smaller report, if any, that's provided during that month. Madam Chair, the quarterly reporting requirements reenacted in each fiscal year budget lacks valuable information to evaluate workforce levels and the staffing distribution needs of each reporting agency. It should be sufficient and made useful to allow auditors, policymakers, and the informed public to evaluate an agency's management practices. This information should be helpful to flag or trigger a staffing audit and pursue improvement to government management practices. Madam Chair, in closing, in conversations with others, I find it amusing that the staffing reports are commonly used to poke upon the salaries and individuals placed within an agency. To summarize, Bill 221 intends to increase transparency by creating greater public trust, especially between employers, employees, and the informed public. Accountability on how public funds are used is the public auditor's work. The legislature's responsibility is to provide a balanced spending authorization on how public funds are programmed and spent. Madam Chair, I look forward to the comments and questions regarding this measure and will work closely with your committee to make any amendments that may help move Bill 2214 forward. Sidus Masi.
Sidus Masi, Senator Taitague, and I'd like to welcome all those who are here to testify this morning. We have first up President of the University of Guam, Dr. Thomas Kreis. Please state your name for the record.
Thank you, Senator. I'm Thomas Kreis, President of the University of Guam. President Okada of the Guam Community College and I agree on the responses to this. I'll just suggest a couple of high-level ones, and I think her comments will sort of elaborate a bit on those. So in general, we support the reporting because we do this kind of reporting routinely. We have staff who are assigned to do this work. We are concerned a bit about the particularly the part-time and student employees that this, that doing this much reporting on people for short-term part-time work, student work, and so on will add a particular burden to our staffing, which is already under stress because of budget issues. So I'd encourage the legislature to consider the workload that's involved in trying to do this. So we already do much of this kind of reporting. Another concern is the publication of personal information. So the kind of thing that we would not normally make readily available to the public. And you can see the kind of what the effect of social media has on people's individual lives as they're, so if you're reporting on things like somebody being demoted or someone, being transferred, being let go, those kinds of things, we typically don't publicize and make easily available. Making it available, staffing patterns for appropriate oversight makes perfect sense. We're happy to do that. We do a lot of that already. And so tweaks to that make sense. But I think, exposing our employees to harassment and ridicule and those kinds of things is that's something to take into consideration in this. And so I would just urge us to be cautious about that. But in general, we support the idea of reporting, and we do lots and lots of reporting. We're doing a lot of data collection throughout the educational system. We're doing a lot better on reporting on the progress of students and everybody. So we're very much interested in data management, clarity, transparency, and so on. But I just would urge careful consideration for the effect on individual employees and their lives. So thank you, Madam Chair, and thank you, Senators.
Sidus Masi, Dr. Kreis. Welcome, President of the Guam Community College, Dr. Mary Okada. Please state your name for the record.
Happy day and good morning to all of you. My name is Mary Okada, President of the Guam Community College. Happy holidays. I am happy to participate and continuously participate in accountability and transparency of our public funds and in our role as stewards of the people's money. There are a couple of things in this legislation, in this bill, that I would just like to seek some clarification, because as line agencies and our autonomous agencies have different infrastructure as in terms of financial management. So I just wanted to get some clarification on perhaps some of the areas that you're looking at. So on page 3 of the, let me just start with the on page 2. So as Dr. Kreis referred to part-time employees, normally a staffing pattern produced by the organization doesn't include the part-time employees that we have. The staffing pattern is for all full-time employees, whether they are permanent, whether they are on soft funds, whether they are, so usually the staffing pattern is for full-time employees. And so if this is to include part-time employees, we have substitutes that come in and out based on their availability. We have student tutors, we have student work studies. So we just need some clarification because on page 2, section 2, B2, it says the employee's employment status, and it says full-time or part-time. And so just clarification if you really want part-time to be included in the staffing pattern, because it's not currently on there. And then going to page 3, where it talks about on number 6, where it talks about funding source shall be delineated from general fund, federal funds, special funds, and to include funding name and account number. So the account number is unique to the entities. And so if you're under the DOA system, then they have a different account format and structure. So the account number here at GCC UOG would not be, it's not anything that is consistent across the government of Guam. Funding sources are easy to identify. Account numbers are really unique depending on how the organization has it structured. And so those are, so that issue of account number, just wanted to get clarification because of its uniqueness. Under section 3, where it talks about the monthly personnel information reports, under A1, where it says all new hires and termination of employees. So termination of employees has a, just in how it's stated, has a negative connotation. Termination of employees could be just because the funding source is no longer available. But, you know, because you say you've been terminated, or if it's under the heading of employees terminated for the month, it really isn't a, it's not, you know, the employee's fault that the funding ran out. So I think maybe if you want the information, maybe new hires and or some other way, because it, you know, in my opinion, it just has a negative connotation, and sometimes, many times, termination of employees has to do with funding expiration. The other thing is that there is a law, and I just haven't had time to look it up, but there is a law that was passed several years ago that talked about references for employees during the recruitment process. That when individuals are asked to give a reference, that we are cautioned as to whether or not our reference is going to be a barrier for somebody seeking employment. So if you now have on your website for the government of Guam list of terminated employees, I as an employer would probably want to see if you were terminated. And that may not be a good thing for the recruiting agency to see, and it will have a negative effect on the employee. And so I asked for clarification on that because, like I said, termination of employees may be funding and may be a barrier for somebody who is looking for employment. And if that is public knowledge, it would be a problem for that individual. On page 4, under section 3, number 2, where it talks about demotions. And so demotions, and I understand demotions can be voluntary. And so there have been instances where an employee may volunteer to take a lighter or to take a lower positions because of maybe some physical constraints. And so some demotions may be voluntary. And again, demotions has a negative connotation. So I don't think we really want to highlight somebody who's been demoted if it really is for personal reasons that they choose to either take on a different position because they no longer want to be in a supervisory role. And maybe just some clarification on that, because again, demotions may be voluntary. Otherwise, the other components of the requirements, we have been providing staffing patterns and posting it on our website for many years in accordance with all the budget laws and the provisions of the budget laws. They are made available. And if you have any questions regarding anything I've brought up today, then please let me know. I'd be happy to answer them. So just Masi for giving me this opportunity.
Thank you very much, Dr. Okada. Would the sponsor of the bill like an opportunity to address any of those points?
Sure. And I noticed that the director, Jesse King, is here, but if you don't mind, Jesse, I just wanted to zero in on the comments that were made. You know, Dr. Okada, I thank you so much. Your recommendations are very valuable to strengthen this legislation, as well as yourself, Dr. Kreis. I appreciate you being here today. You know, So Dr. Okada, do you have any recommendations then, using another word other than demotions, or with regards to termination, do you have any recommendations on maybe a section that provides the reasoning for termination, as you mentioned, maybe to include a section for that explanation? Oh, you're on mute. Sorry, Dr. Okada.
So I guess it's going to be dependent upon what is the intent to receive the information. So if we understand what the intent is to receive a list of the terminated employees or the demoted employees, then maybe we can help craft how that may be. Because listing people that have been demoted or terminated is one thing, but providing the reason why on a website is even further punitive to the employee. And so, just the changes in the numbers of employees. So for example, if I have a staffing pattern this month that has 250 employees, and next month I have 255, and it's clearly identified based on the staffing pattern and you'll see it that there's a new federal funding source, then that would, in my mind, if I'm analyzing it, be easily available for me to pull that out without basically saying I've got new grants and stuff. You'll be able to see that. In our staffing pattern, we identify all the vacancies that are at the department. And so normally we try to keep, for all the government of Guam employees, you'll see that over the years, if I have 201 employees, that number has remained consistent for many years. Where there will be changes are in the grant funds, contracted funds, and that's where you're going to see the up and down on the number of employees there. But like I said, to report folks that have been terminated, because if it's a funding source issue, you'll see it if you want it separated by fund, and maybe we're already separating it by funding source. Then if the number of employees for that funding source goes down, then it's highly likely that it's because the funding has run out. So I would personally prefer to keep terminated employees or demoted employees from being highlighted. It's already on there. It's just I would prefer that they're not highlighted. Highlighted in the staffing pattern.
Well, it is good information, especially for OPA, to see how many people are being employed, and on a monthly basis, because then it jives with the quarterly report. It's much easier to read, especially your quarterly reports. If you're looking at a monthly report that's coming out, and then, because by law right now, currently by law in the budget bill, it requires, like Dr. Kreis, you're mentioning the information, it requires the name of every current employee, their position title, and and how much money they make. That's a lot of, that's good information to provide. And so I think, we're dealing with federal funding, which has to be reported anyways. And we're also dealing with local funding. And this just provides a layer of transparency and accountability, and most especially to be able to cross-check, from one report to another, which we can't do, until 3 months later. But I do have a question. Does Bill, and anyone can answer, Dr. Kreis or Dr. Okada, does Bill 221 have an impact to the academic freedom required by WASC or UOG's GCC accreditation?
I don't believe so, because you're not interfering into who we're hiring or how we're hiring them. This is simply information.
Okay.
Now, in all the accreditation visits I've done, and I currently sit on the commission, I have not seen any other institution publish their salaries of their employees on a public website. So it's unique to us, but and we understand why. But in all the accreditation visits, it's not on the public website how much folks make. It really is contained personnel information that accreditors review in terms of the hiring criteria, but it's not publicly made available.
Okay, but it has no detriment on your accreditation. Okay, thank you. Dr. Kreis, if you wanted to answer.
Oh, just to agree, I don't think that it does. We'll review that and submit a written testimony, but I don't think so off the top of my head.
Thank you so much. Thank you, Madam Chair.
Thank you very much, Senator Taitague. We'll now move on to testimony from Mr. Kinga from the Guam Ethics Commission. Please state your name for the record.
Thank you so much, Senators. Hafaday, good morning. My name is Jesse King. I'm the Executive Director for the Guam Ethics Commission, here to provide testimony on Bill 221. Generally, the Commission has, I've spoken to the chairperson. She asked that I share our testimony. We're in support of the intent of the bill in the promotion of transparency. Generally, after hearing of the testimony from the two presidents, we concur with their recommendations. We did have other points that we wish to present for consideration by this body. Primarily one, if the body will consider adding the Guam Ethics Commission as an entity to receive such reports. One of the statutory requirements for the Ethics Commission is to conduct ethics and government training for all GovGuam employees. And we're typically provided 2 timelines for existing employees. They have 36 months from the enactment of that public law, while new employees have 6 months. So it's particularly challenging for our agency to get a handle on who these new employees are in order to accurately time when they should get their ethics training done within that 6-month time span. The second, which I think is more of a broader conversation, is on the topic of enforcement. I'm not sure if the bill had discussed or provided what would be the repercussions should an agency not comply with the statute. Is there any entity that is led with responsibility for ensuring that this is answered to and properly posted as mandated should this bill become law? And with that, Senator Shelton, thank you, Madam Chair, and thank you to all the senators. I'll be available for any follow-up questions that you might have.
So Swasi, Mr. Kinga, we'll open the panel for questioning now. We'll begin with Speaker Terlahi. Do you have any questions?
Well, I would just ask GCC and UOG, and how do they describe when a grant ends and that position ends? How do you describe it? Is there any action that's required, like another GG1 at the end of that period? I know they're hired for a specific period. Do you have to do another personnel action at the end of the grant period? And what is that action?
So when we hire folks on limited term employment for under grants, it has a start date and an end date, usually in alignment with the grant. So the only time we issue any additional GG1s is if there's any modification to the original GG1, either extending the time or decreasing the time because they've resigned prior to the expiration of the funds. So normally if someone comes in and it's a 3-year grant, then we will issue the GG1, usually on a limited term. Employees are always on a yearly basis for 1 year, even if it overlaps between fiscal years. And so we'll issue a GG1 for 1 year at a time on an LTA employment. And then at the end of that final GG1, if there's no extension, then it will just end. We don't issue anything else after that.
Okay. Would it be accurate to describe instead of termination these as separations? I think what we're trying to do is, you're right, we could look at the staffing patterns month or quarter to quarter and compare those, but it's for all the agencies, for us to do that for all the agencies, this is a much more concise method so that just the changes are highlighted. And so I don't want, I hear you about the stigma, but I still think it's a very valuable tool for us to see the changes in hiring and I've called up some agencies and said, how come I don't see this person who I know works for you on your staffing pattern? And they said they don't report federally funded employees, and I don't understand why not. I think so. I like the parts of this bill that say that all employees. I think we can discuss a little bit more about the part-time. I still think those should be reported if at all possible, because yeah, we're just trying to, you know, ensure different things with this information. And it would be very useful for me, for example, in reviewing GMH's hiring and public health's hiring, which are huge agencies, if we could get these in this type of format. But, oh, wait, one more question. What do you do when you have an above step hire and you publish that on your website? Do you take it down or do you leave it up, or how does that work for your agency, for GCC?
So above step recruitment in our agency is quite rare. And so it's a action taken by the board. So it is available through our board meetings. And you know, I think since I've been here and since I've been the president, the only above step recruitment I believe we've ever done has been for nurses. And that's because of the difficulty in recruitment.
All right.
But it is a board action.
Okay, I'm just asking because I'm wondering if I could include those as part of this reporting requirements, but all right, thank you very much. Thank you, Madam Chair.
Thank you, Speaker Terlahi. Senator Dueñas, do you have any questions?
No questions at this time, Madam Chair. Just wanted to appreciate the presence of the panel and the discussion so far. Thank you, Madam Chair.
Thank you very much. Senator Perez, any questions?
Thank you, Madam Chair. So yeah, I'm also interested in balancing transparency with a protection of personal information. And so as far as what systems you see that could, you know, balance both of those initiatives. So I know, for instance, in the medical field, there, you know, you can code things, right? Or when we see in these public audits, they code, they give a generalized information that could be potentially posted on the website, but you know, upon request and approval, the information can be more detailed. So I think maybe, what are your thoughts on that? I think this is for President Kreis and President Akata.
Thank you, Senator. I would just say, whatever, I'm not exactly sure, maybe we can get that to you in written testimony, exactly what would be a way to avoid, shining a light on an individual person, making it easier to harass that person or whatever. So some other, the current method, it just takes the effort to do the comparison to see, you can still do it with the current systems. You're asking for something that's easier to do that. And what we're saying is there's just concern about highlighting that information in a way that is detrimental to individual employees. So I'll look into providing some other language that might achieve that end and submit that in written testimony. That's all right, Senator. You're muted.
Yeah, thank you. I appreciate your response. Dr. Akata, if you have any thoughts on that.
Yeah, so in some, well, one way to do it would be to redact the names of the employees, but that is not, you could redact it because, but there are, multiple individuals that hold the same title. So you kind of have to figure out, if you had 20 program coordinators, who the bodies were behind it. Now, in terms of right now, the information that we have for employees is by name and title. We're not displaying any social security numbers. When we provide listing of students, for example, we always redact the student's name and use their what we call their BOO number, which is their student number. And so we just for students, we would take that name out. So if in the event that you are intending to include part-time students, we would ask for special consideration for students that we just identify how many student tutors to keep their names out. If that could be a consideration, just to say we have, so many student tutors, just to, to provide them with a little bit more confidentiality if you wanted to provide part-time info. And other than that, the staffing pattern as it currently is, it's available on our website because our budget is on our website. The staffing pattern is included. So, the budget every year that is presented is on there as well. So that's, if somebody wanted to FOIA our staffing pattern, they could potentially FOIA the staffing pattern. So, if it needs to be provided, it needs to be provided. It's okay. It's just adding the additional folks that, the part-time employees and student employees that I would just ask for some consideration, because it would be very minimal. Now, one other way to provide information to you in terms of the number of employees that have increased or decreased is probably when it refers to federal funds or so, we can just simply explain it in a short narrative. And that might be, something helpful, because federal funds have begin dates and end dates, and those are provided in our audit reports. The terms of those grants are in our schedule of federal awards. So it's easy for us to track those. In our staffing pattern, we do identify those that are on the general fund, manpower development fund, non-appropriated funds, and federal funds. And so we identify the offices associated with that. So there's a lot of information already on there. I'd like to go back to Senator Terlahi's suggestion to have it say separation as opposed to termination. And maybe if we include the word separation, but that would include everybody who's retired. So then now we're, separation could be retirement, could be death, could be, other, moving to another agency and that sort. So separation might be a little bit more, it's a different classification, but it can include all of those. People that have been terminated would be on there, but separated might be a better term. Okay, that's all. That's all I have. Thank you.
Okay, thank you. Yeah, limited terms. Do you guys, did your agencies have a lot of limited term appointments? Yeah, so are you open to also reporting those as well?
We already do, full-time.
And what about, I know limited terms have a timeline that they can, be employed. What about stating the length of time, like the cumulative time that they are employed for? Are you open to that as well?
So what will happen, the current staffing pattern has date of hire, and the date of hire for limited term can be shifted depending on, what grant they're on. So date of hire is already on there. So if that were the case, then your request would be to add another column for end date if they do have an end date in terms of their funding source. But then you won't see an end date for any of the general fund employees.
Okay. So
or the non-appropriated, yeah. Oh, it would only show up for those that are on LTA.
Okay, so just to clarify, there will be an end date, but if there's a new funding source, does that start the cycle again for a limited term?
Mm-hmm.
It does. Okay.
Mm-hmm.
Okay. All right. Thank you. Thank you, Madam Chair.
Thank you very much, Senator Perez. And now we'll end with the author of the bill, if you have any questions, and to give your closing remarks.
Thank you, Madam Chair. If I may, please, for the record, I'd like to read into the a testimony that I'll provide your the Vice Speaker's office as well as yourself. a testimony by Chris Barnett on testimony of Bill 221 for the record. This is from Chris Barnett. I'm writing as a private citizen to provide testimony in support of Bill 221. The more transparency, the merrier. It is a constant struggle to obtain information and documents from the administration, and even with Freedom of Information Act requests and current reporting requirements for staffing and personnel in place, the timelessness and willingness with which information is provided, if it is even provided, leaves much to be desired. While government agencies may argue that they are already taxed by existing reporting standards with the amount of suspected hiring being done ahead of an election year, I think there are plenty of warm bodies around to work to adhere to the perimeters of this legislation should it become law. Given that most of the agencies brag about how far they've come relative to digitization of documents and procedures, complying with the mandates proffered in this bill should be no problem at all. It is very troubling to report on the prefla of $10,000 raises, but step recruitments for political hires and other questionable occurrences weeks or months after they have occurred, since these are the delays the current protocols allow for. I strongly feel this bill helps to enforce a reluctant administration to be all in when it comes to transparency. Signed, Chris Malfunction Barnett. Thank you for allowing me to read his testimony into the record, Madam Chair. And I greatly appreciate all the comments that were made here today. It's very valuable coming especially from Dr. Kreis and Dr. Okada. But I greatly appreciated Director Jesse Kanga, your comment. I've been one to, provide that teeth in bills, and I actually failed to do that in this bill. I'd like to thank you for reminding me that it's important to provide that enforcement, that teeth mechanism. If agencies don't provide this information, there should be some kind of repercussions with regards to that. And I will definitely look into that. I appreciate too the fact that you would like a copy of this monthly report, but I'm pretty sure this report, not only for this legislature, but if anything, it should be posted on their website, because it's just not for us as officials in the government, but for the public to see where their hard tax-paying money is being spent on and who they're hiring with that money. So I really appreciate your testimony to Mr. King for that. The current law right now requires names, titles, salary amounts. I'm not looking at anything that's going to, put any kind of detriment to any individual, that works for the government of Guam. But any funding that is spent, whether it's local or federal, should be identified and recognized for everyone to be able to review. So other than that, Dr. Okada, I do agree with the part-time students. That could be tedious, and it is students, so I don't have an issue with that. However, part-time employees still may be questionable, but I'll work with the committee chair in putting something together. And I truly like a separation, that word separation. Now we just need to come up with a word for demotion. That's next. So looking forward to a written testimony so that we can be able to refer back to your testimonies as we work on this legislation to make it a stronger legislation, and the intent, which I'm very happy that you both are very supportive of the intent of the legislation. So hopefully I can get your support once we've come to a good consensus. And I wish you all a very Merry Christmas, a Happy New Year. Please be safe. Thank you, Madam Chair.
Fiducious Masi, Senator Taitague. With no further questions or testimonies, the Committee on Public Accountability, Human Resources, Guam Buildup, Hagantya Revitalization, Regional Affairs, Public Library, Telecommunications and Technology, hereby concludes this virtual public hearing. Written testimonies may be submitted via email at Senator Muña Barnes at guamlegislature.org or via Dropbox at the Guam Congress Building, 163 Chalan Santo Papa, Hagåtña, Guam, until close of business on Friday, January 4th, 2022. I want to thank everyone for being here today. President Okada, President Christ, Mr. Kenga, Siduos Masi for your testimony and for your time. And to all of our colleagues and those at home watching, Merry Christmas, Happy New Year. Please have a safe holiday season. This virtual public hearing is now adjourned. The time now is 10:22 a.m. Siduos Maasi, adios.
Thank you. Merry Christmas, everybody.